May it please the Court, I'm Thomas Kienbaum. I'm here on behalf of the petitioner appellants. With me at council table is Mr. Carl von Ende, who is the Miller Canfield firm's acting general counsel. I was asked by the Miller Canfield firm to defend its properly authorized, elected and appointed agents in connection with this claim, which attacks their decisions, which they made pursuant to the terms of the operating agreement. If you will focus on the underlying claims, Mr. Altobelli asserts that over 5 years he was undercompensated, which of course is something that the managing directors of the firm are tasked with doing, namely to provide for compensation, and that the firm's CEO and others did not allow him to take a leave of absence, and that somehow this also violated the firm's operating agreement, the underlying agreement that contains the arbitration clause. So there is no question here, number one, that we had properly authorized agents of the firm. After all, a corporate entity can only act through its agents, so they have to appoint somebody to do that. These people had the authority to do what they did. And secondly, the plaintiff centrally attacks the operating agreement as having been violated. So this is a claim essentially under the operating agreement, and we contend it is a claim against the firm. The plaintiff fails in his quest to avoid the arbitration clause, at least on the basis of two doctrines that the court has asked us to address, and that is agency and estoppel. We submit that there's actually a third doctrine that would bring about the same result, namely that arbitration is warranted. And that is the doctrine of an intended beneficiary, someone who is intended to be the beneficiary of the arbitration clause. And that, of course, implicates, or is so because of Section 3.3 of the operating agreement, which says that every principal of the firm is entitled to all the covenants and agreements of the operating agreement. The arbitration clause, of course, is one such agreement and covenant that inures to the benefit of all the partners, all the principals. And the fact that the operating agreement also provides for indemnification for the kinds of actions that partners take pursuant to their assignment obviously underscores that the firm fully believes that this is a claim against it. Now, the case law we have cited to the court with respect to agency, to start with that. And by the way, as an aside, Mr. Altobelli initially, we believe, recognized that this was a claim against the firm because he did file for arbitration against the firm with AAA, and it sat there for about 7 months until he apparently decided that another forum would be more advantageous to him, and he dismissed that proceeding and then went to Ingham County Circuit Court. The case law we have cited, we believe, uniformly, I don't think as to agency, there is a decision that is different or adverse to our position. And that holds that when an agent performs on behalf of his principal, her principal, and there is an arbitration agreement between the plaintiff and the principal, but not the agent. The agent is not a signatory to that agreement. The agent is nevertheless entitled to the benefit of that arbitration clause. That is, we submit, uniform law, and that is, of course, one of the prongs the court has asked us to address. Now, I won't go through these cases, of course. I think the Sixth Circuit's Arnold decision, which has been picked up, unfortunately, in only 2 unreported decisions of the Michigan Court of Appeals, but is uniform in terms of the statement, where the court says, I think very appropriately, if a plaintiff could avoid the practical consequences of an agreement to arbitrate by naming only non-signatory parties as defendants in his complaint, or signatory parties in their individual capacity only, the effect of the rule requiring arbitration would in effect be nullified. Now, Arnold also rejected, and that's the Sixth Circuit case, rejected the argument by the plaintiff there that the agents were acting, or were acting outside the scope of their authority. In other words, unauthorized action. That should take it out of the arbitration clause. The court said no, as long as it relates to the ambit of their responsibilities, whether they were right or wrong, that doesn't matter. They are protected or entitled to the benefit of the arbitration clause.
Mr. Kienbaum, the only question I have is, why is this case in this court? Why is this case being heard in this venue? I thought that when a contract or an agreement along the lines of the operating agreement in this case incorporated some document or some rules by reference, those rules in fact applied. And as I look at your agreement, you've incorporated by reference the AAA rules, and one of the AAA rules says the arbitrator shall have the power to rule on his or her own jurisdiction. That is the threshold arbitrability of this case. Why then are you asking this court to resolve that issue as opposed to having the arbitrator, who clearly under the AAA rules seems to have the authority to rule on his or her own jurisdiction?
Well, of course, what we're asking the court is to do precisely that, to direct that it go to arbitration.
But I'm talking about something threshold even to that, wherein we make that determination by the arbitrator's exercise of judgment.
Well, Justice Markman, the question of arbitrability quite often, though, is, regardless of what the rules of AAA may be, is a question for a court. And in other words, that's sort of a jurisdictional first instance determination, as opposed to procedural matters which are for the arbitrator.
The rules give the arbitrator the authority to rule on his or her own jurisdiction, and objections with respect to the scope of the arbitration agreement are also within his authority.
I certainly don't want to disagree with Your Honor, because I think it gets us to the same result that we're urging.
Well, it's the same result, except that it seems to me one of the premises of the arbitration process is that we have an economical and efficient way of resolving disputes without implicating, all the forces that operate within this court. And by virtue of the process that we've gone through, it seems to me that we've defeated a lot of the virtues of arbitration, have we not?
Well, that's unfortunately the fault, we would say, of the trial court and of the Court of Appeals. Obviously, Miller Canfield, or rather the defendants, its agents, have always contended that's precisely what ought to happen. But when we get adverse decisions, we're obviously, unfortunately, forced to come to this court to get that resolved.
Has either party at any level of the proceedings raised the argument that the decision, the threshold decision, the initial decision here ought to be made by the arbitrator himself or herself?
Your Honor, I don't recall whether that was raised at the trial court level or at the appellate level, and I think one of the reasons for that is that, as I said, the question of arbitrability is, generally speaking, in the first instance, to be decided by a court.
I'm having some confusion here. I thought this became a circuit court rather than an arbitrary activity because the plaintiff postured this as a claim against his former partners rather than the firm itself.
Yes, Your Honor.
The partners themselves independent of the firm. As soon as the firm becomes implicated, the arbitration clause kicks in. But if it's postured as an action against the individuals, that's how we got here, isn't that it?
Yes, Your Honor.
Okay.
And that's obviously the question. And that's the question whether, isn't this really a dispute with the firm, because it centrally implicates the operating agreement of the firm, and obviously a dispute with the firm has to be about the operating agreement. And that's where you then identified the doctrines of agency and estoppel as being...
Is Miller Canfield a necessary party under 2.205?
I don't think it's a necessary party, because we contend this is essentially a claim against the firm. The firm's obviously there.
If it is postured as the plaintiff is postured, is the firm a necessary party? Or may, if the arbitration is out and it's permissible to proceed as the plaintiff has postured the claim, is the firm a necessary party?
If the court here decides that this is in essence a claim against the firm as postured. And if the doctrines of estoppel and agency...
No, I'm posing, I mean, the big issue here is the firm actually the party here? But I'm now trying to just sort of parse it. Okay, let's take it as pled by the plaintiff as against individuals. Is the firm nevertheless, under our rules, a necessary party?
Your Honor, I think whether or not it is down below, once it gets sent back to arbitration, is probably...
Yeah, but you don't get to arbitration unless we say the agency or some other principle. This is, we are looking past how the plaintiff has characterized his claims and seeing this is really a claim against the firm. If we don't get there and it's still postured as the plaintiff has pled it, I'm asking, nevertheless, isn't the firm a necessary party?
Well, I think it is.
Actually,
I think it is a claim against the firm. I think it is therefore essential.
Is
It's
an
an
essential party if it was proceeding without the arbitration in play?
I'll take that, an essential party. And but to be clear, we always. I'm retained by the firm. The firm's there.
If the firm is a necessary party,
I'm trying to figure out why you're fighting this.
I'm not.
Is it a necessary party?
I'm simply
Can relief
careful.
be granted without the firm being involved?
I think the firm is a necessary party in the sense that the claim is against the firm. And if we get technical, which arbitration...
And the gravamen of the complaint is that these individuals subverted the plaintiff's entitlement under the partnership agreement.
Right. And if one is to be technical, and maybe I'm mischaracterizing your inquiry, but if one is to be technical, then yes, this is a claim against the firm, and under standard pleading practices, you ought to properly state a claim, and that's the way it started, and that's the way it didn't end up. But in that sense, the firm is an essential party. It's going to be there defending the actions of its agents, obviously.
Is the firm's presence essential to permit the court to render complete relief?
I believe you can, because even as it is postured, the current defendants are entitled to the benefit of the arbitration clause, and the court below said they are not. So if you disagree with that premise, you certainly are entitled to reverse the court and say arbitration applies here and they are entitled to it. And whether or not an arbitrator then decides that the firm ought to be formally named, I suppose we could leave that to the arbitrator. I submit it wouldn't necessarily make a lot of difference, but perhaps that is an appropriate objection to make at the time if only the individuals are still named as respondents.
Counsel, is there an understanding that the firm is going to indemnify the principals that are named in the complaint?
I'm sorry, Justice Bernstein, I missed the first part of your question.
Is there an understanding that the firm is going to indemnify the principals who are named in the complaint?
Yes, Your Honor. There is a provision for indemnification in the operating agreement, and we believe that underscores the notion that obviously this is against the firm. And the only argument we heard about the inapplicability of these cases that are so uniform, which, by the way, interpret the Federal Arbitration Act, this is a firm in interstate commerce, is that they were not signatories, that in those cases the defendants were not signatories to the agreement, and here we have signatories, and I frankly don't understand that, because it seems to me that being a signatory makes our argument even more compelling, because let's assume the firm had assigned these duties to a non-lawyer operating manager, and that operating manager had, for instance, been delegated the responsibility to decide compensation, and if he is then sued for his decision, I gather that what the appellee would say, he would be entitled to the protection of the arbitration clause, but we, as members of the firm who signed the arbitration agreement, are not, and that doesn't make any sense to us, of course. I think it's just the other way around. Estoppel, to the same effect. I love, obviously, Justice Easterbrook's observation that when you sue under an agreement, but sue only the non-signatory to the agreement, then you are attempting to weasel out of your, and those are his words, weasel out of your obligation to resort to arbitration. We believe that this is a case against the firm. The operating agreement is centrally implicated. Obviously, estoppel establishes throughout that.
What, obviously, do you think, if you prevail, what, do you think an opinion is needed here?
I'm sorry, an opinion is needed? Mm-hmm. I would assume that this would be
What is the rule that you expect to emerge from this court if you're successful?
The rule would be that the Court of Appeals is reversed as to its holding that the arbitration clause does not cover this dispute because, as defendants, only the managers, the duly authorized managers, are named. But that under various doctrines that uniformly hold, under those circumstances, the arbitration agreement covers the dispute. As in Stark-Reagan, which I think is rather relevant, I see my time is up, this court peremptorily reversed. I think that would be appropriate here. Perhaps arbitration law requires a more extended opinion, but we will be very happy with the peremptory reversal. Thank you very much, Your Honors.
Good afternoon. Mark Granzato on behalf of the plaintiff appellee, Mr. Altobelli. He's at counsel table with me as co-counsel as well. I waive any self-imposed limitation on the questions the court may offer.
Let's start out with the obvious. Isn't this suit entirely about the plaintiff's entitlements under the partnership agreement?
The underlying claim? The underlying claim, contrary to the way Mr. Kienbaum described it, is a damage action against individuals. It is a damage action seeking, obviously, monetary damages, which is a response to the suggestion that there's somehow an issue with respect to whether there's a necessary party on behalf of the firm. But the fact is, this case is pled as a case against perhaps ultra-virus activity on behalf of individuals. Mr. Altobelli's only remedies in this case are against those individuals. He has no remedies against the firm the way this case is pled. And that's pretty significant, it seems to me, in light of what Justice Zara has raised with respect to whether there is, in fact, a necessary party. But
isn't it, Mr. Gonzalo, aren't your allegations against the specific defendants for acts committed in their management role with the firm? I mean, could they have committed any of the conduct alleged in the underlying action for their managerial role?
I'm not going to debate. I'm not going to debate the question or challenge the question of whether this claim arises out of or is related to the operating agreement. And the reason I can concede that is because this is a really strange arbitration clause, and unlike most arbitration clauses, it does not have a provision of arising out of or related to. There is no such provision in this particular arbitration clause. But Mr. Kienbaum has, in his 15 minutes here, done the impossible, because he has talked about this particular arbitration clause without ever once discussing what the language of that arbitration clause actually holds. And the fact is that we all know arbitration is consent, arbitration is contract, and there is only one limitation in this particular arbitration clause, only one, and it is the limitation that the dispute involved has to be between the firm and a principal. That's the limitation. I heard Mr. Kienbaum, if I counted correctly, use the terminology of non-signatories about 6 times in his argument. I heard him talk about between the firm and the principal 0 times. The fact is, and this is, I'm in front of the right court for discussing these particular principles of freedom of contract. The fact is, these are people who can draw up a contract in any way they so choose. What they chose to do was to adopt a contract in which there was one significant limitation on arbitration. And the only limitation is it has to be a dispute between the principal and the firm, and that's not this case.
How does the firm act but through its managers?
You are absolutely correct under law.
So you mean it's
That's
just a
the only way.
meaningless-
And think about what that means. You have learned people, sophisticated people who know precisely that corporations only act through agents. Now, how hard would it be to write an arbitration provision which does encompass those agents? They chose, for whatever reason, good or bad, they chose to adopt one which says only between the principal and the firm. That's the only limitation.
Maybe they didn't need to because they understood that maybe they didn't need to use any more words because they understood that agency principles would govern here. So when they say the firm and any of its principals, they mean the firm, which can only act through its agents, and therefore they meant the firm and its agents.
Well, the very use of those two words in the same clause does in fact separate the two, it would seem to me. And in fact, if you go to the section 2 of the operating agreement, you will see that the firm is defined. You'll see also that principles are defined. Therefore, not just under the law, because the law does not create an identity. This is pretty important. The law does not create an identity between a principal and an agent. It does not. And the fact is that not only overlaying the law in this case is the actual contract that is at issue, and that contract separates clearly the principal from the agent. So to suggest, as I think the defendants get around to doing in their, particularly in their supplemental brief, that there is some sort of identity between these two is completely incorrect. But let me just talk briefly about non-signatories. If this court had a non-signatory case, this court should grant leave and decide it because there are serious issues with respect to non-signatories. But here is the question that's presented here. My client makes a promise when he signed that operating agreement. He made a promise that anytime he had a dispute with the firm, that dispute would go to arbitration. It turns out the defendants made the same promise. They promised. What's happening in this case is they must somehow change my client's promise. They must somehow change the language of this agreement such that Mr. Altobelli, in a case that's solely against other principles, is somehow required under a contract, under an arbitration provision that is confined to disputes between the firm and principals. He's got to arbitrate that. Now, there is a vast body of law which this court has never weighed in on. It had a chance in the Ruecker case a few years ago, but it denied leave in the Ruecker case. But there's a vast body of law on the question that exists with respect to whether a non-signatory can enforce an arbitration award. What is key in this case, contrary to what Mr. Kienbaum has just told you, we don't have non-signatories. We don't have people who did not sign this contract. What is at issue in all of these federal cases, I should not confine it to federal cases, there are a lot of state cases as well, but the question, the central question presented in all of these cases is, can a non-signatory enforce? The question presented here is not one of enforcement. They can enforce. Why? They're parties to this agreement. They have the same status as Mr. Altobelli. They can enforce this agreement. But, and this is critical in terms of the way this court has approached contract law, and that is they have the right to enforce the contract that was written, not a contract that they want to rewrite, because fundamentally that's what is at stake in this case. They must rewrite this contract because they must somehow have you ignore the very language that Mr. Kienbaum spent 15 minutes up here ignoring. They must get you somehow to write out of this contract that the limitation on arbitrability is in fact only to disputes between the firm and the principals.
Mr. Gonzalo, what does a dispute look like between the firm and a principal if it's not about the conduct of one or more of the firm's agents? Describe what is arbitrable. What would that dispute look like?
Well, I don't know exactly what it would look like, but I'll tell you what it would look like in the caption. It would be Dean Altobelli versus Miller, Canfield, Paddock, and Stone. And I can tell you that that's not what the caption in this case is. Now, I assume there are hundreds and hundreds of disputes that could arise. But again, these are sophisticated people. These are sophisticated lawyers. If they want an arbitration agreement that includes disputes between principals, it's not particularly hard to write. Not hard at all. They could have done so.
I think one of the asymmetries that exist here is, had these been non-lawyer managers, therefore non-signatories, they would have the benefit of the doctrines of the non-signatory. No?
No, because look, what the federal courts have done is they have allowed non-signatories to enforce. What you cannot do, especially under this court's jurisprudence with respect to contract, freedom of contract. Remember, the overarching theme of freedom of contract, two parts. One is you have such free will to order your affairs in any way. But the second prong, and you've obviously written on this many times, the second prong is courts have to enforce. In order to guarantee freedom of contract, courts must enforce contracts as they're written. That means that if we have a case in which this court, let's say, adopts what Ruecker did, it adopts what Arnold did, it adopts the view that an agent or somebody for equitable estoppel reasons does in fact have the right to enforce. What they have is the right to enforce the arbitration agreement as it exists. In other words, let's say they were non-parties. Okay? They're non-parties to this case. What they gain by being non-parties, let's say this court does in fact follow Arnold, let's say the court does in fact follow Ruecker, and says that these non-parties in this particular situation can in fact enforce the arbitration award. The arbitration agreement. What do they get to enforce? They must enforce the arbitration agreement as it is written. Otherwise, if that's not true, then this court is in the business of rewriting contracts. But they get to enforce. If they're non-signatories, which of course they're not, but if they got to enforce, they can still only enforce the arbitration agreement as it exists. And they would be in exactly the same position because the arbitration award as it is written is limited to disputes between the firm and the principal. That's the arbitration agreement. That can't be altered. You can't change. This would be antithetical to everything this court has stood for, it seems to me, in the realm of freedom of contract, in the realm of contractual interpretation for the last 15 years. Because the suggestion that not only do they get to enforce the contract, but they get to change the contract, to take out those nasty words that Mr. Kienbaum spent 15 minutes up here ignoring. That's the position they want you to take in this case. They are asking you to ignore the actual language of the arbitration provision. And that's something you cannot do, consistent with what seems to me 15 years of pretty significant dedication to the idea of freedom of contract.
Anything else?
Well, there were a couple of... Justice Markman posed a question. I must tell you, in terms of jurisprudential significance, the issue that you raised has never been briefed before, and that is the question of the jurisdiction of the arbitrator. Far more jurisprudentially significant than anything that the defendant happened to have brought to the table during the course of this. But It's never been briefed in this case. If you'd like briefing on this issue, I'm very much willing to do it, but it's a very interesting question you've raised. There are two issues here. I do not understand the difference between them. You mentioned jurisdiction. I see jurisdiction as something very different from arbitrability. And I see arbitrability as, particularly obviously in a case that's instituted in the circuit court, arbitrability and the interpretation of a contract is something that belongs to the circuit court. Now, I'm speaking, I can tell you, without having done any legal research, because the issue you've raised is in fact an issue that has never been briefed in this. It hasn't been raised. And I can tell you that in terms of the jurisprudential significance, what you have raised is far more significant than what they have raised during the course of this case in light of the specific language of the arbitration provision that we are dealing with here.
All right. Thank you very much. Case is submitted. We're concluded for the afternoon.